Justice Sotomayor.
Counsel Myers, which you rely on, was signed by a number of judges. One of them was Justice Sutherland, and he was the author of Humphrey's executor. So 4 out of the 9 justices who signed on to Myers signed on to Humphrey's. So you're thinking, or you're arguing, that the reasoning of the more current justices on this court have more purchase than the views of renowned jurists like Holmes and Brandeis, who dissented in Myers, of people like Justice Story, who disagreed with this proposition. You're suggesting that we have a better view than either Congress or all of those previous justices about what absolute executive power means. That's basically your argument. All those justices in the past have been wrong, and the current ones are right, or at least the current ones of the Shigella law majority.
I'd say 2 things in response to that. I think the court was correct in the following decisions: Ex parte Hennon, Parsons, Shurtleff, Myers.
Those all involved different and distinguishable situations. Now, with respect to the one component of government that you're not speaking about, when the FTC was created, as has been the case with most of these independent agencies like the Federal Reserve, particularly there, but not that much lesser with the FTC, Congress emphasized the importance of independency and the prestige that that independence would give to the decisions of agencies who are going to subject the public to rules and regulations of which there might be burdens. And that independence is being taken out or undercut completely. Why are you so sure that Congress would have preferred to have the independence narrowed than not to have the agency at all? Some of my colleagues have suggested in prior cases that we shouldn't be engaged in the severability actions at all. But here you are arguing that, no, we should be doing that. Why? Are you going to be consistent?
The prestige, I would say 2 things in response to that. The prestige of independency is not a constitutional value. The constitutional value is the separation of powers and the vesting of all the executive power in the presidents. That is the
according to the
value
laws that Congress makes. And that's the point Justice Jackson was emphasizing. What you're saying is the president can do more than what the law permits.
I think I would repeat what I said before. There's a strong line of precedent recognizing that the text and structure of the Constitution confer on the president the exclusive and illimitable power to remove executive officers, and as a result of that, Humphrey should be overruled.